Hi everybody. Today we are looking into a question which perhaps intrigues most of us. Do I need an arbitration agreement in any contract that I enter into? Now, what is this arbitration agreement? Now, arbitration agreement traditionally is one of the things which are there in a contract, the end portion, where we look into the dispute resolution mechanism when and as and when we have any kind of disputes between the contracting parties. Now, usually it is not something that you should be concerned about, but in the changing atmosphere in India with regard to dispute resolution process, it is this arbitration clause should be a deal breaker, absolute deal breaker. Once we get into a contract and we sign in it, and there is a dispute resolution mechanism which insists upon an arbitration, then what you are traditionally doing is that you are telling and agreeing between the parties that there can be no going to court directly. The disputes have to be resolved through a private enterprise whereby an arbitrator will be appointed and he will decide who should be getting the claims, who should be getting the benefits, and all the disputes have to be placed before him or her. Now the question is whether we should have an arbitration agreement or not. Unlike what we go through courts, arbitration per se is an extremely expensive mechanism in India. Yes, it is quicker, the remedy is quicker, the dispute resolution process is quicker. With the new amendments in place, it has to be resolved within 12 months and it can be extended for 6 months. There are certain exceptions to this rule, and then you have to go to the High Court to get the extension for the arbitrator, which is also getting very prevalent, that there are extensions, but then at least there is a curb. So when we are talking about having an arbitration agreement in our contracts, we have to evaluate where we stand. If it is a contract which has a huge financial ramification, huge sums are involved, then yes, you should always have an arbitration clause. That will ensure that you will have a very quick disposal of, at least relatively quicker disposal than going to courts and finding it out in a commercial suit. But otherwise, when the financial implications are not very large, or it may not be suitable, then perhaps we should decide not to have an arbitration clause. Go to the court, go to anywhere, but it will be a much cheaper mechanism rather than going in for an arbitration. It is not that if we go to have an arbitration clause, that is, we will be completely dispensing with the court. No. The arbitral award can always be challenged in a court of law. Thereafter, for the execution, that is getting the money or any kind of mechanism which has been given by the arbitrator, you still have to go and knock on the court's door for execution of the same. Arbitrators cannot execute their own orders. That is not possible. That always has to be done by a court. So the challenge to an arbitral award, which is minimalistic, and the scope of challenge is also limited, that always is there in a court of law. So it is not that you are completely taking the court of law out of the question. But for a quick disposal, yes, you should always have an arbitration if the finances related to the contract permit it. It has to be always a very important business decision that you have to take. If your contract does not envisage that kind of financial ramifications, mark my words, if it does not, then please do not have arbitral agreements in your contracts. It will be counterproductive because you will be paying so much money to the arbitrator as per the Schedule 4 that it will not make any logical sense. There are minimum amounts which have to be paid to the arbitrator. Now one may say that very well, even if I have an arbitration agreement, I may not go by the arbitral process. Well, then all the parties have to then decide that they will not go. If you file a case, somebody would file an application in that court, the other side, and say no, I will not go by this process of court resolution. It has to be referred to an arbitral tribunal, because that is what our contract envisages. And the law is very, very clear. It has to be given, delegated to an arbitration process. So my advice to many people who go blindly into contracts without noticing this dispute resolution clause is that please have a look, evaluate it. It is one of the risk evaluations which you have to take when you are going into an arbitration and going into signing a contract. Is it worth having the arbitration? Another thing which I must tell most of my friends here is that when you are getting into and looking into a contract, please look into the details of the arbitration clause. Sometimes it envisages 3 arbitrators. No, that again is not required. That you will appoint one, the other person will appoint one, and another umpire. Costs are a very big facet of this. So if the money amounts are huge, ramifications are huge, then yes, perhaps you should look into more than one arbitrator. Otherwise, please stick to single sole arbitrator. The next thing is the seat of arbitration, or where the arbitration will take place. Please look into that. This should be a deal breaker. Now, if you have an arbitration clause which envisages that arbitration will be somewhere else, you also have to factor in a lot of money which will have to be paid for your lawyers and for your representatives to attend those arbitrations in a particular out of city location. Those things have to be factored in when you are entering into a contract. After evaluating this, then only please agree to have an arbitration agreement in your contract. Otherwise, decline it. This should be a deal breaker. Many a case happens when parties are not able to get a dispute resolution, are not able to challenge some other arbitrary or breach of the contract, mainly because it is not financially viable to do so. Arbitration, again I repeat, in India is an extremely expensive process. The other small aspect is when you are going into an arbitration clause, deliberating it, please mention in your contract that the fees of the arbitrator will be subject to 4th schedule of the Arbitration and Conciliation Act. It is required law, otherwise it can go beyond. Arbitrators can go beyond. Sometimes it is very important that we actually mention this. That is one aspect. The second thing that you must also do is clearly specify that you want one or more arbitrators. If it is not given, then by default it is one arbitrator. These things have to be clearly spelled out in your arbitration clause, as also where the arbitration will take place. Thank you. I hope this is informative and helps people. Thank you. Next day again.